It's 9:25. You are listening to the Keith Hansen Show on WNTK and WUVR, 99.7 FM, 98.9 FM, 1490 AM, and streaming online at WNTK.com. 526-9464. If you would like to jump in on any portion of the conversation, you're welcome to do so. 526-9464 or 888-299-3151. That's 888-299-3151. Well, Tiger Woods coming off a big win. Well, he's going to have another battle to fight, and not on the greens. It's going to be in court. Tiger Woods and the general manager of his Florida-based restaurant were served with paperwork regarding a wrongful death lawsuit that was brought by the parents of a 24-year-old bartender of the Jupiter, Florida-based establishment. Nicholas Immensberg had an estimated blood alcohol concentration of 0.28. That's over 3 times the legal limit when he died after a motor vehicle crash where his vehicle left the roadway. The lawsuit that was filed in Palm Beach County yesterday alleges that Immensberger was served or overserved for about 3 hours after his shift at the Woods before the fatal crash. Now, what's interesting about this, Tiger was not there. Tiger's not behind the bar polishing glasses and serving up shots of rot gut. But the lawsuit alleges, quote, Tiger is individually liable in this action because he individually participated in the serving of alcohol. That doesn't mean that Woods either served or was even at the Woods that day, but under different types of liability law, Tiger Woods could still be individually liable. So to get the perspective on this, I've invited Rob Crain on the program. Rob's a nationally renowned personal injury attorney with a pretty extensive history of successfully litigating personal injury and negligence claims. He's an attorney out of Dallas, Texas. Rob, great to have you on the program. Thanks so much for joining us this morning.
You bet, anytime.
All right, so Tiger Woods is not even there, but he could possibly be personally liable for the injuries or death sustained by this young individual who was allegedly overserved at his restaurant. How exactly does that work?
Well, I don't think it's likely to work. Florida law, these are called dram shop cases where you're trying to hold the server of alcohol liable for the injuries to a person like this or an injury to another should this individual have caused a wreck that hurt somebody else. Those are very restrictive laws in most states. And in Florida, they're even more restrictive because you can only be liable as a server or a person who furnishes alcohol if you knowingly serve a person who you know to be habitually addicted to alcohol. So more to your question, Tiger Woods individually, they're going to have to come up with some unique theory that is circumvents the dram shop laws in Florida for him to be held personally liable based on the facts as we know them now. So I don't expect that individual claim, based on what we know, to have a high likelihood of success at this point.
Okay, so now for Tiger individually, but so his girlfriend, for instance, or other people who were in the bar, the bartender, whoever was over serving. That's one of the things. I've owned 3 nightclubs in my lifetime, and so that's one of the things that we've had to look out for. We've had to train bar staff on, especially is number one, being able to recognize a person who's underage and recognize a fake ID, but then also being able to recognize the warning signs of a person who was intoxicated, how to tell and how to know exactly when it's time to cut somebody off. And you pay a lot of insurance for that as well, too. You pay a lot in insurance for that. So, I mean, is this a situation where the insurance companies would wind up picking up the tab? I mean, how exactly does that work? And, it seems like no matter what you're doing, if you're serving alcohol, you're, at least in some degree or fashion, opening yourself up to potential liability.
Well, it's interesting. A lot of states handle this differently. I'm based out of Texas. We practice all over the country, but in Texas, part of the law is if you are a restaurant or a provider of alcohol and you have all of your employees trained, certified through training in the service of alcohol, despite what happens, you have immunity from these suits. If every one of your servers, and they've got to all 100% be certified, then the state says, look, we're encouraging you to properly train your individuals. If they are properly trained and you've got everybody trained, you've got immunity from these kinds of cases. So with individual servers, and to your point with Tiger's girlfriend, who's was or maybe still is the general manager there, again, in her individual capacity, unless she was there and doing something individually, she's not going to have liability. Now, as an employee, as the general manager, if she was promoting some kind of, employees have access to alcohol to the point of intoxication regularly, and that's their practice, then the company could be responsible for her conduct in an employee role for their vicarious responsibility for her. So when it comes to liability and the states and how they view this particular type of liability, there's a lot of variance between the states, and it's really a fine line here on what we want to promote from social drinking responsibility to serving responsibility. And it really, our laws in these states really do promote a certain kind of conduct, whether it is to be more safe in the service of alcohol or whatever it may be. And to your question about insurance, most insurance companies require you to carry a liquor liability policy, that policy to cover you in instances like this. And if you just have a general policy, most of those general policies have exclusions that don't cover this kind of a claim. So typically, servers of alcohol must carry an additional type of liquor liability coverage.
So let's talk about, you mentioned the word vicarious. Let's talk about vicarious liability and the concepts of respondeat superior. That's wherein it's a legal doctrine, really, where an employee or an employer, more specifically, is liable for the negligence or the performance, good or bad performance, of a person that they're supervising.
So the law, generally speaking, for companies across America, and again, it varies from state to state, and it varies from the type of claim. If somebody commits an act of negligence in the course and scope of their employment that hurts somebody else, then typically the employer is, as you noted, respondeat superior. That doctrine kicks in, and the company is responsible financially for the damages caused by their employee. Now, if the employee is not in the course and scope of their employment, or they have done something, let's say they're on the job, but they are at a job site and they get into an altercation with somebody and assault somebody, even though that person was on the job at that time, assaulting that other person would not be part of the course and scope of their employment, and the employer would not be responsible for that. So typically it's limited to when they're doing things. An electrician out on the job is not properly wiring things up and there becomes an explosion. Well, then the company's responsible for all of those damages caused by their employees' negligent conduct. So it's meant to be there so that when you have significant injuries and so forth, when a company is acting through their employee, that company is there to back up their work, to back up and pay for any damages caused by their work. Mm-hmm.
Now, okay, so this opens up, and I love getting into this, tort law. I think tort law is one of the most fascinating things ever because of the different ways. I look at liability as almost like water. Liability has the ability to creep into even the smallest, most microscopic breaches. And once that water gets in there, once that liability gets in there, then, I mean, who knows what the outcome is going to be. It could be a leak where you just simply have to dry it out, or it could be something that, I mean, I think about it like an iPhone. Once you get even the smallest amount of moisture in your iPhone, okay, well, you may have to shut it down and dry it out for a little bit, or it may completely short out the inner workings of that electronic device. Similarly, once liability finds its way in, it has an amazing ability to metastasize.
Well, that certainly can be the case when we're looking at some widespread liability. When you're talking about, we're seeing this on a daily basis in the pharmaceutical industry. It seems like you can't put on a 60 Minutes episode without them running a story about something going on where the pharmaceutical industry has colluded to either jack up prices, or at least allegedly, or they've done things in the opioid market where they're trying to distribute those as quickly as they can, those types of things. And once you you have that type of widespread liability that affects so many people, then you certainly can put your company at jeopardy. Typically, though, liability is, for individual incidents, and typically that's why, you have insurance and so forth. And philosophically, our country has generally taken a view that, look, we want folks to have responsibility, accountability for their conduct. Also, from a social standpoint, if somebody gets hurt due to the negligence of another and there is no way to get compensated for that, many times in our country, the injured person is now unable to care for themselves, unable to pay their bills. They're going to the county hospitals, and the taxpayers are paying that bill. It happens every single day, thousands and thousands, if not tens of thousands of times a day, where somebody injured at the hands of another can't get their bills paid, and now the taxpayers are paying it. So there's a couple of theories here of accountability, responsibility for your actions, number one. Number two, we want to make sure that those accountable are the ones causing the injuries are paying for those and not our taxpayers. And number three, it also goes philosophically to a larger issue of regulation. There are many in our country want to decrease the amount of regulation that we have on companies and individuals. And many of those same proponents, lawmakers who want to decrease the laws on regulation for particular industries, though, do want to support our liability laws so that when they are given the freedom, the lack of regulation, to act in the way they believe is best, if they go out and start abusing that freedom, they can still be held accountable in the court of law through our liability laws. So philosophically, it all kind of works hand in hand if we're going to try to promote accountability, try to promote those who have caused injuries to pay for those rather than our taxpayers. And also, in many instances, if we want to give freedom in this country to act with minimal regulations, when you do take advantage of that, or when you don't properly take the freedom, you're going to be held accountable when you're not doing the job that you should be doing. So it really works in many different layers in our country, and it's a very, very important part of the fabric of our economy and the fabric of our rule of law.
What are your thoughts on tort reform and where our civil system happens to be right now in terms of litigiousness? There's a lot of people who say, you know what, we need tort reform, that we're just in this litigious nature right now where people get sued for the slightest amount or the slightest inference of wrongdoing. Obviously the tort system is good because it does help hold companies accountable, but how much is too much? Just yesterday, was it? I forgot what chemical company it was, but the makers of Roundup. Another $100 million judgment against the company for allegations that their product causes cancer. Where do you see ourselves right now on the landscape of tort reform and the litigiousness of our society?
Well, you bring up a good point. Tort reform is, a term that was created in large part by the Chamber of Commerce back in the National Chamber of Commerce. They put $60 million 1 year plus into a tort reform campaign that created a lot of news. You remember the McDonald's coffee spill case.
Yes.
They used that case as their champion for tort reform, this frivolous lawsuit. This woman spilled coffee on herself, and lo and behold, when you actually get down to the facts of that case and what actually happened in that case, you appreciate and understand what the jury did and why they did it. To your bigger question of tort reform, there's not the idea that there are just the courts are flooded with frivolous lawsuits is not the case in my experience in practicing across this country. Are there frivolous lawsuits that are filed? Absolutely. Are there people who are opportunists in filing things and trying to get press by suing potentially? This may be an instance where Tiger Woods gets sued individually when he may not have any individual responsibility whatsoever. Do those things happen? Yes, they do. But the vast 90+% of the claims that are filed have a basis of legitimacy in them. And what has happened with tort reform is that mantra has been used to pass laws that most people don't know about in their individual states. And what happens is when they get hurt, they realize, oh my goodness, I can't get a fair measure of recovery because of these tort reform laws. I thought these tort reform laws were supposed to weed out these frivolous lawsuits. And what tort reform laws actually do is the businesses and insurance companies don't care as much about the small frivolous ones. They know juries are going to take care of those. They know if there's a massive verdict, like what you mentioned in the Monsanto case yesterday and the Roundup case, that the appellate courts are going to take care of those large verdicts and make sure that those are in line with reason and responsibility. What tort reform laws have done is they attack the legitimate cases so that there are caps placed on the legitimate cases, because that's where insurance companies get hit. Is they get hit hard with those legitimate cases. So tort reform is a concept that came up as a marketing tool, and what has happened in many states, and my state especially in Texas, the pendulum has swung very far to the right in this regard, and there are unfortunately backlashes which are occurring. In our state, the medical industry is capped. They can kill a non-wage earning person in the medical profession, and that person's life is only worth $250,000. Well, what's happened is our medical care in the area has decreased. The quality of it has decreased. And because there's no accountability. And unfortunately, we see that daily. But unfortunately, there's not much in the way of recourse from these for individuals because of these tort reform laws. So when you hear that term tort reform, everybody hates frivolous lawsuits. I hate frivolous lawsuits. They back up. If I get behind one in the court system, I've got to wait, longer to get my legitimate cases to trial. So that's one of these marketing tools that everybody, when they hear it, needs to make sure, okay, am I being sold the proper statistics? Am I being given the right evidence? Or is somebody just trying to skirt responsibility on what might be a legitimate claim? So tort reform is a hot-button issue, as you can tell probably partly from my answer, but it's one where we all need to be taking a step back and going, wait a minute, what's really happening when somebody is saying we need tort reform?
All right, we're gonna get more into this here with the individual responsibilities as well as the responsibilities of the employers. Plus, if you have any questions for my guests, certainly you are welcome to call in 526-9464. It's a great opportunity to ask an attorney a question. Attorney Robert Crain joining me on the Keith Hansen Show. We'll be right back after this. It's 9:42.
This is the Keith Hansen Show on 99.7 FM WNTK and 98.9 FM WUVR.
9:46, you are listening to the Keith Hansen Show on WNTK and WUVR, 99.7 FM, 98.9 FM, 1490 AM, and streaming online at WNTK.com. Rob Crain, nationally renowned personal injury attorney and successful attorney litigating negligence claims. Always interesting when we start getting into tort reform and avenues of liability. We opened up talking specifically about the Tiger Woods case. Tiger Woods yesterday was sued because somebody in his restaurant based in Jupiter, Florida, had overserved an employee. And as a result, the employee, the allegation was that he overserved this employee for about 3 hours. And then this individual with a blood alcohol level of 0.28 wrecked his car on the way home and sustained fatal injuries. Well, now everybody and their brother get sued. And, Rob, I'm kind of curious what your thoughts are on this, because I've noticed in a lot of cases, a lot of civil suits where it's like, well, sue everybody. And, who knows? You just throw everything at the wall, and if something sticks, well, it's just a bigger payday for certainly for the petitioner and also the petitioner's attorney.
No, I would agree with you that lawyers at times will over-include in their claims, and I understand what they're doing conceptually. They're trying to make sure that they have all the proper named parties, because as we are in today's age, many companies, I've got one now, where there's a company that has almost 100 subsidiaries, and it's hard to figure out which company is which, and which one has responsibility and liability, and you want to make sure that you have those entities in your lawsuit before your deadline, your statute of limitations runs. But to your point, if somebody has not done anything wrong and they have been included in a suit, they're looking at potential attorney's fees as well as negative publicity out there. And I think our system could do a better job of accommodating not only some of the strict rules on some particular type of claims, but therefore allowing lawyers a little more flexibility not to over-include in cases. But certainly those companies or individuals who get brought in for the wrong reasons or just because of over-inclusiveness, that can be detrimental, certainly to them.
So, I mean, if is insurance enough? If you're a business owner, is it enough just to have insurance? And I mean, how far over that? What are things that people can do to protect themselves? Only doing business under a corporation, for instance, or under the protections of an LLC? What are your recommendations?
Well, the best
WNTK.
thing that you can do, obviously, is best business practices, having quality safety programs, quality safe business practices. That first and foremost is going to carry you through your career, and in many instances avoiding.
All right. So what's the okay? So Rob, hold on 1 sec, because I'm feel okay. I'm going to put a caller on actually, Rob, for you. Hold on 1 sec. Rob, let me do this. Let's take a quick break here. I'm trying to get a phone call transferred over for you, and it's not cooperating. Let me just get through a 30-second commercial here, and we'll get this caller over.
Keeping your medication straight can be challenging. At Colonial Health Mart Pharmacy, our medication packaging system makes that challenge a whole lot easier. We will package all your prescription and over-the-counter medications in one easy open packet. No guessing, no sorting. We work with your doctor to ensure that your prescriptions are always up to date and the best choice for you. If you have a question, we're just a phone call or text away. Call our helpful pharmacy staff and tell them you'd like your prescriptions packaged today. Colonial Health Mart Pharmacy, caring for you and about you.
All right, that's what I get when I try to do two things at once. I'm trying to not micromanage, but multitask here, Rob, and didn't quite work out there. So, all right, I got a caller on the other line who wants to ask you a question, if you don't mind. Caller, first name and what town you calling from, please.
I'm Dave from Tilton. I got a question. I've used attorneys in the past, and I know that they're invaluable when you need them, but I do see guys like John Edwards who made millions of suing companies. And well, when somebody loses a big lawsuit or they involve libel to somebody and those people are innocent, General Flynn is for an instance. Why don't U.S. laws, or how come the suing people don't have to pay off these people for their negligence of suing and oversuing and adding in extras and all this turmoil that they put people through? Like if I let my kid use my car and he lets his friend borrow it and they get in an accident and somebody dies, they can not only go after my insurance, they can go after my house, my kid's house, my uncle's house. What stops that? Countersuing or automatic, you pay everybody if you fail. How does that? Why isn't that our law?
Well, there are many states that have enacted several measures. Some have gone so far as to have a loser pays for court costs and some attorney's fees if there is an adverse verdict against the plaintiff. Other states, and Florida's one of those, at least it used to be when I had a wrongful death case down there, they can they can make a demand. And in that demand, the plaintiff can make a demand, or the defendant can make an offer, a reasonable offer in their opinion. And let's say the defendant makes a reasonable offer and the plaintiff says no to it. And then the jury comes back and the jury gives an award similar to what the defendant offered. Well, at that point, under some laws, the states require the plaintiff to then pay for the attorney's fees that happened from the time of the reasonable offer up and until the time of trial, because it could have settled for that amount when that reasonable offer was made. There becomes it gets complicated in laws in making such a blanket rule that loser pays because it has a bunch of adverse results. But to your point, that is a frustration of a lot of folks who feel like they have been brought in wrongfully, and they ultimately go out and win their case, and they're still saddled with a whole lot of attorney's fees without the ability to go after the person who sued them, because the person who sued them likely didn't have much in the way of assets anyway. And to your secondary question, they go after your house or so forth when you don't have sufficient insurance or so forth. I'll tell you what's happened in this state, this country, is 18-wheelers are only required across this state, the nation, to carry $1 million in insurance. And that $1 million of insurance requirement has been in place since the late 70s, early 80s, and buses that carry 50-plus people on them at a time have had a $5 million insurance requirement. Again, that's been the same amount since the late 70s, I believe, early 80s. And we've got to be more responsible in this country about requiring sufficient insurance for industries so that when they're, when an 18-wheeler hits a family car, it's going to do a lot of damage. Same thing when a bus has a major accident. And the biggest thing we can all do for ourselves is to be properly insured. We do have protections from people losing their home. Those homestead laws allow for people to always be able to protect their home, and typically a couple of cars and up to an amount of money, personal property, and so forth. So we do have protections out there, but they can always, and they should be. Your question is very well taken and should always be discussed, and we should be always revamping our laws in these areas. And like I mentioned, always looking at, are we requiring sufficient insurance for particular industries? Doctors in the state of Texas not required to carry any insurance whatsoever. Neither are lawyers, and I don't think that's responsible.
Dave, thanks so much for the call. And Rob, we're going to have to wrap up here. We are getting close on time, but great conversation. Certainly appreciate your insight and your expertise on the matter. And I guess it's all the more reasons just to not even get out of bed in the morning. If you don't get out of bed in the morning, then you don't have to worry about encountering any situations where you could possibly be liable to somebody else for negligence or anything else. Of course, I say that tongue in cheek, but I have to say I'm a big person on insurance. I think insurance is definitely the way to go. It's a great vehicle to protect you from unforeseen losses in the event of an unforeseen occurrence. That's exactly what it's there for. Robert Crain, I want to thank you again so much, and we'll get you back on again soon. Appreciate it.
You bet. Anytime.
All right. Have a great day. 9:55, you are listening to The Keith Hansen Show on WNTK and WUVR, 99.7 FM, 98.9 FM, 1490 AM, and streaming online at WNTK.com. Going to wrap it up right after this.